1. And first, the courts of common law have the superintendency over these courts, to keep them within their jurisdictions, to determine wherein they exceed them, to restrain and prohibit such excess, and, in case of contumacy, to punish the officer who executes, and in some cases the judge who enforces, the sentence so declared to be illegal. 2. The common law has reserved to itself the exposition of all such acts of Parliament, as concern either the extent of these courts or the matters depending before them, and therefore, if these courts either refuse to allow these acts of Parliament, or will expound them in any other sense than what the common law puts upon them, the King's Courts at Westminster will grant prohibitions to restrain and control them. 3. An appeal lies from all these courts to the King, in the last resort, which proves that the jurisdiction exercised in them is derived from the Crown of England, and not from any foreign potentate or intrinsic authority of their own. And from these three strong marks and ensigns of superiority, it appears beyond a doubt that the civil and canon laws, though admitted in some cases by custom in some courts, are only subordinate and legis subgraviori lege, and that, thus admitted, restrained, altered, new-modelled, and amended, they are by no means with us a distinct independent species of laws, but are inferior branches of the customary or unwritten laws of England, properly called the King's Ecclesiastical, the King's Military, the King's Maritime, or the King's Academical laws. Let us next proceed to the legis scriptae, the written laws of the kingdom, which are statutes, acts, or edicts, made by the King's Majesty, by and with the advice and consent of the Lords Spiritual and Temporal, and Commons, in Parliament assembled. The oldest of these now extant, and printed in our statute books, is the famous Magna Carta, as confirmed in Parliament 9 Henry III, though doubtless there were many acts before that time, the records of which are now lost, and the determinations of them perhaps at present currently received for the maxims of the old common law. The manner of making these statutes will be better considered hereafter, when we examine the constitution of parliaments. At present, we only take notice of the different kinds of statutes, and of some general rules which regard their construction. First, as to their several kinds. Statutes are either general or special, public or private. A general or public act is a universal rule that regards the whole community, and of these the courts of law are bound to take notice judicially and ex officio, without the statute being particularly pleaded, or formally set forth by the party who claims an advantage under it. Special or private acts are rather exceptions than rules, being those which only operate upon particular persons and private concerns, such as the Romans entitled Senatus Decreta, in contradistinction to the Senatus Consulta, which regarded the whole community. And of these the judges are not bound to take notice, unless they be formally shown and pleaded. Thus, to show the distinction, the statute 13 Elizabeth chapter 10, to prevent spiritual persons from making leases for longer terms than 21 years, or 3 lives, is a public act, it being a rule prescribed to the whole body of spiritual persons in the nation, but an act to enable the Bishop of Chester to make a lease to A.B. for 60 years is an exception to this rule. It concerns only the parties and the bishop's successors, and is therefore a private act. Statutes are also either declaratory of the common law or remedial of some defects therein. Declaratory, where the old custom of the kingdom is almost fallen into disuse or become disputable, in which case the Parliament has thought proper, in perpetuum rei testimonium, and for avoiding all doubts and difficulties, to declare what the common law is, and ever has been. Thus, the Statute of Treasons, 25 Edward III, Chapter 2, does not make any new species of treasons, but only, for the benefit of the subject, declares and enumerates those several kinds of offence which before were treason at the common law. Remedial statutes are those which are made to supply such defects, and abridge such superfluities in the common law, as arise either from the general imperfection of all human laws, from change of time and circumstances, from the mistakes and unadvised determinations of unlearned judges, or from any other cause whatsoever, and this being done either by enlarging the common law where it was too narrow and circumscribed, or by restraining it where it was too lax and luxuriant. This has occasioned another subordinate division of remedial acts of Parliament into enlarging and restraining statutes. To instance again, in the case of treason, clipping the current coin of the kingdom was an offence not sufficiently guarded against by the common law. Therefore, it was thought expedient by Statute 5 Elizabeth Chapter 11 to make it high treason, which it was not at the common law, so that this was an enlarging statute. At common law also spiritual corporations might lease out their estates for any term of years, till prevented by the Statute 13 Elizabeth before mentioned. This was therefore a restraining statute. Secondly, the rules to be observed with regard to the construction of statutes are principally these which follow. 1. There are 3 points to be considered in the construction of all remedial statutes: the old law, the mischief, and the remedy. That is, how the common law stood at the making of the act, what the mischief was, for which the common law did not provide, and what remedy the Parliament has provided to cure this mischief. And it is the business of the judges so to construct the act as to suppress the mischief and advance the remedy. Let us instance again in the same restraining statute of 13 Elizabeth. By the common law, ecclesiastical corporations might let as long leases as they thought proper. The mischief was that they let long and unreasonable leases to the impoverished of their successors. The remedy applied by the statute was by making void all leases by ecclesiastical bodies for longer terms than 3 lives or 21 years. Now, in the construction of this statute, it is held that leases, though for a longer term, if made by a bishop, are not void during the bishop's life, or, if made by a dean with concurrence of his chapter, they are not void during the life of the dean, for the act was made for the benefit and protection of the successor.